on immigrant communities, যেটা নিয়ে আমরা সবাই more or less কম বেশি ভয় আছি, including thousands of Bangladeshi nationals who live, study, and work in the United States. From visa backlogs and asylum denials to deportation proceedings and increased enforcement actions, the challenges are many and complex. Today's seminar seeks to address three key areas. It is what is currently happening in the US immigration landscape, the specific legal and policy challenges faced by Bangladeshi nationals, and the potential solutions and policy options that can help protect the rights and futures of our people. Before we begin, I would like to extend a heartfelt thank you to the Michael Piston Law Office, a leading firm in immigration law. Their team has long been a trusted advocate for immigrant communities, including many from Bangladesh. Now, it's my great honor to introduce our speaker, Attorney Ms. Michael E. Piston, a nationally recognized expert in U.S. immigration law and the senior attorney. With over 42 years of exclusive experience in immigration law, Mr. Piston has personally overseen the successful filling of more than 10,000 employment-based green card applications and an equal number of non-immigrant applications. His primary focus lies in representing foreign professionals and U.S. employers in employment-based immigration matters, particularly in the fast-paced IT and software consulting industry. Attorney Piston's commitment to justice and his remarkable track record of success making an invaluable voice in today's conversation. So before we go to Mr. Piston, I would like to request Mr. Lokman Bhuiya to start our program today. His small speech.
ধন্যবাদ। গুড আফটারনুন। আমাদের প্রোগ্রামে আগত অতিথি এবং মিডিয়া পার্সোনালিটিস, আমরা আজকে এই প্রোগ্রামটি আয়োজন করেছি ফর দ্য রিজনস ট্রাম্প অ্যাডমিনিস্ট্রেশন আসার পরে আমি দেখতে পেয়েছি, শুনতে পেয়েছি যে আমাদের কমিউনিটি অনেক ইমিগ্রেন্টরা আতঙ্কে জীবনযাপন করছে, অনেকে গজবে জীবনযাপন করছে। সো আজকে আমি আমাদের মিডিয়া বাইরের মাধ্যমে ইমিগ্রেশন যে পরিবর্তন এসেছে এবং কিছু কিছু ইমিগ্রেশনের নীতি নির্ধারণ অনেকের জন্য ফেনিক তৈরি করছে, এগুলো আমাদের মিডিয়া ব্যক্তিত্বের মাধ্যমে আজকে আমাদের কমিউনিটি বাংলাদেশি ভাই বোনদের কাছে ছড়িয়ে দিতে চাই সঠিক তথ্য এবং সঠিক উপাত্ত। আপনারা সবাই আজকে আমাদের অনুষ্ঠানে যোগ দেওয়ার জন্য আপনাদেরকে ধন্যবাদ এবং আমাদের প্রোগ্রাম শেষে আপনাদের খাবারের জন্য আয়োজন করা আছে, আপনারা সবাই আমন্ত্রিত এবং খেয়ে যাবেন। থ্যাংক ইউ, গুড আফটারনুন।
Thank you. We'll start with a keynote presentation by the Michael Piston Law Office, offering expert insight into the legal landscape and current enforcement trends in U.S. immigration. So, এই সব কিছুর জন্য যাকে আমরা এখন ওয়েলকাম করব তিনি অবশ্যই আমাদের আজকের মধ্যমণি। And now, without further delay, I'm pleased to welcome our Michael
Advocate Law.
Please join me in giving him a warm round of applause as he shares his expertise on the U.S. immigration crackdown and what it means for the Bangladesh community. Please welcome Mr.
Well, as I guess you've heard, my name is Michael Piston. I'm an immigration lawyer. I'd like to correct my introduction. I actually, although I've been practicing law for 42 years, I've only been practicing immigration law for about 40. But it seems like 42. Primarily, for most of my career, I have been, as mentioned, a business immigration lawyer. And in fact, I have 2 offices in Michigan right now that do nothing but represent software consulting companies and their employees. But starting around 2011, I decided that I was bored of doing that kind of work, and I would rather do litigation. So I moved to New York and started concentrating on bringing federal lawsuits against the U.S. CIS courts and property of immigration benefits. And I still do quite a bit of that. But in 2023, I was very surprised to have been discovered by the Bengali community. And I started receiving numerous cases from people who were in removal proceedings or had applications pending for the asylum office. And initially I was kind of reluctant to take these because, frankly speaking, I'd never done anything with that. Mostly the asylum cases we saw there were Chinese or people from the Middle East. And believe it or not, I really knew almost nothing about Bangladesh except A, you had a civil war in 1971, which the United States, of course, helped their opponent. And number 2, that you had lots of floods. And number 3, you had lots of fires in your textile factories. That was pretty much the sum total of my knowledge of Bangladesh. I never heard Sheikh Hasina. I was unaware that the country was under dictatorship for 15 years. So, nevertheless, when I started reviewing the cases that were coming into our office, I started seeing that there was a real need for competent representation of people from Bangladesh in their community. I saw cases of people who were ordered removed because they didn't tell them when their hearing was. I saw people who lost their case because, among other things, they met the attorney who was representing them in their case about 10 minutes before their hearing. I saw many cases where people clearly had never been prepared at all for their testimony and it showed. So I decided that it was necessary to start accepting these cases so that we could ensure that the people were receiving effective representation, especially when I started hearing some of the stories that they told me about vicious assaults upon them, kidnapping, attempted murders, and in some ways, worst of all, the fact that even when they left Bangladesh, their family continued to be persecuted. And their female relatives would be sometimes sexually assaulted, sometimes even raped. It was a very, very sad situation. Worst of all, I think, were the cases of people, of women, sometimes even girls, who were forced into marriage because their suitor kidnapped and raped them. This is very, very shocking to me, and clearly these types of cases cried out for effective representation. So that's when I decided to open an office in Jackson Heights, and since then we've kind of been bombarded with cases, even though we haven't done advertising. I guess this counts as advertising. But, so, what I understand today is that there's a lot of concern, quite rightfully so, about the policies of the new administration, and in particular, President Trump's threat to engage in mass deportations. So I'd like to address that, and I'd like to define what the government can and cannot do, and how much of a threat this threat of mass deportations is to the typical person from Bangladesh who is here in an unlawful status. Now, I've been really surprised to hear that some people are permanent residents are concerned about these. Generally speaking, a permanent resident cannot be removed from the United States unless A, he commits a fairly serious criminal offense, or B, he departs the United States for more than a year. Now, neither of these things automatically cause a permanent resident to lose their status, but at least raises issues. And sometimes people who have been outside the United States for more than a year, when they come back into the country, the Customs and Border Protection will tell them that they've abandoned their residence, and that they should give them their green card. And unfortunately, sometimes people believe them. And that's another, something more that's simply not true. The Customs and Border Protection is like this. Customs and Border Protection Office. The Customs and Border Protection Office has no authority to terminate someone's permanent residence. They do have authority to take their physical card, but then they have to replace it with temporary evidence of permanent residence. So if the Customs and Border Protection thinks that somebody has abandoned their residence in the United States, they can issue what is called a notice to appear before an immigration judge, and at that time, the person will have the opportunity to prove that he has not abandoned his residence. And if he doesn't believe, if the judge doesn't believe him, he can appeal that decision to the Board of Immigration Appeals. He can appeal that decision to the Second Circuit Court of Appeals. As we'll talk a little bit more in detail, he can keep the case going about 10 years, even in the worst cases. So this is something that people should be careful about. People should avoid staying outside the United States more than a year at a time, but it's certainly not the end of the world if they do that. Of course, there are some criminal convictions which can have very serious immigration consequences for them. It can not only result in them being put into removal proceedings, but it actually can result in them being subject to mandatory detention. And as we're going to talk a little bit more today, people who are detained are in a very difficult situation. So, what exactly does it mean when Donald Trump says that he is going to engage in mass deportations? Well, surprisingly enough, for most of the people who are here even in an unlawful status, that is kind of an empty threat. Because the Donald Trump, even though he probably thinks so, doesn't have the authority to order somebody removed. Only an immigration judge can order somebody removed. And to even come to the attention of an immigration judge, you first have to be issued what's called a notice to appear. So if you're issued, if somebody who is here, who has overstayed their visa, for example, this comes to the attention of the Immigration and Customs Enforcement Agency, they can issue him a notice to appear before an immigration judge, and that immigration judge can order him removed. But if he has some kind of, he can avoid removal for a very long time if he has some form of relief. So, for example, let's say that a person has come here as a visitor and overstayed their visitor status, and then they are put into removal proceedings. If they have a fear of returning to Bangladesh because they might be persecuted because of their citizenship, nationality, religion, political opinion, membership in a particular social group, then they can apply for that relief before the immigration judge, or they can apply for some other forms of relief, such as cancellation or removal, which is a form of relief which is available for people who have been here for 10 years or more and who have U.S. citizen or permanent residence, parents, spouses, or children who would suffer exceptionally extremely unusual hardship if they were detained, or if they're eligible for justice, they can say that at their master calendar hearing, and then the judge has to schedule them for a individual hearing. Individual hearings right now before judges in New York are generally being scheduled for about 2027. So right there, even if you're put into removal proceedings, it's going to take you 2 years or more even to have what we call an individual hearing, which is a hearing in which a decision can actually be made in the case. But even if you have this hearing, and even if it goes against you, you can appeal that decision to the Board of Immigration Appeals. The Board of Immigration, I've taken an informal survey of the immigration attorneys who are practicing removal law, and it appears that the Board of Immigration Appeals is maybe working on cases that they received in 2020 or 2021. So you're looking at probably a minimum of 4 years that your case is going to be before the Board of Immigration Appeals. So that's, rather than being able to remove somebody immediately, the government, even in the best case scenario from their point of view, could remove you for at least 6 years. Then on top of that, if you file a petition for review to the Second Circuit Court of Appeals, and you convince the Second Circuit Court of Appeals that you have a decent case, they'll stay your removal while your case is pending before the Court of Appeals. And the last time I had a case before the Court of Appeals, it took about 3.5 years for them to decide. So that's basically around 9 to 10 years that a person with a decent case can put off being removed, even if his case isn't good enough to win. So for the typical person who is here as for example, a visa overstay, Donald Trump can talk about mass deportation, but in reality, if you have effective counsel and a decent case, you're not going anywhere for a long, long time. Now, there are exceptions to that. Exception number one is if you are detained. People who are arrested for immigration violations, even simple overstays, can be detained and often are. But in the vast majority of cases, even if they're detained initially, they can qualify for a bond. Either the CBP will give them, the ICE will give them a bond, or in the worst case scenario, they can apply to an immigration judge for a bond. And if the judge finds that they're not a threat to society and they're not a threat of running away, which he does in most cases, then they can get a bond. It might be, the minimum is $1,500. It's kind of unusual to go more than $5,000. And even that amount you don't actually have to come up with, because there are bond companies who basically post the bond for you if you can produce 10%. So typically, for most people, even if they're here in an unlawful status, probably in the worst case scenario, they might end up being detained for a few weeks while they're waiting for a hearing before a judge. Most of them won't be detained at all, and if they are detained, it'll be a short time before they're posted bond. However, there's another exception to this rule, and that is for people who entered the United States without inspection within the last 2 years. If you entered the United States without inspection within the last 2 years, and you come to the attention of the government, you've got a problem. You've got a real problem. Because anybody who's been in the United States for anybody who entered the United States without inspection, that means they snuck across the border, no immigration officer saw them when they were crossing the border. These people are subject to what we call expedited removal. And expedited removal basically means that rather than going to an immigration judge and having a hearing at which the immigration judge decides whether or not you can be removed, the Department of Homeland Security can make the determination themselves that they find that you are removed. And then they could, at that point, remove you literally within a matter of days, unless you ask for a credible fear interview. If you express to them the idea that you have a fear of returning to your home country because you might be persecuted or you might be tortured,
Then they must give you what is called a credible fear interview. And a credible fear interview is determined whether or not you have any kind of reasonable, arguable basis for being granted asylum or what we call withholding of removal, which I'll talk about a little bit more.